Okay.
All right, I'm going to introduce you right away. Thank you for joining us for Bar Talk version November 9th, 2020. And there's been a lot that's happened over the last week. As you know, not only do we have election results processing going on, but we also had our Governor Mills trying to keep us safe, issued an executive order, another one that went out November 4th. And then we have some orders that were issued by our judicial branch. And Angela, I'm going to let you go ahead and share with us just the highlights of EO 16.
Okay, great. Thanks. Welcome, everybody. So you can see what EO 16 is titled there, and I'm going to hit on the highlights. So the first is that face covering requirements, excuse me, my throat, apply in public settings regardless of the ability to maintain physical distance. Then the term public settings is defined, and it's supposed to be broadly construed. And you can go to that EO and read the definition. The third part is that owners and operators of indoor public settings shall post plainly visible signs notifying entrants of the requirement to wear cloth face coverings. And they can deny service or entry for non-compliance. She reinstated the 50-person indoor gathering limit. And she delegated authority to commissioners of the DECD and DHHS to issue activity-specific requirements designed to minimize the risk of transmission.
Thank you, Angela. One of the things that that the court did was revise SJC 6, SJC 7, and please take a look at those. I'd like to cover them in a little more detail in our next Bar Talk, but it does address some timelines. The feedback that we received based on some questions that came back for those is that you should use the more restrictive timeline that's outlined if there's any conflict between the SJCs. The BCD came out with
Thad, your connection isn't very good.
Yes.
But I wanted to also add in that I also heard from Amy Quinlan since that discussion that you should go with the, the more specific rule is that the best advice for attorneys at this point is to discuss the orders with judicial officers at pretrial conferences pending further advisories or updates to the PMOs.
Thank you, Angela. Am I sounding any better right now?
Yes.
Great. And that's really good advice. There's also, of course, the business court has some procedural rules that they've also shared. You can go to the website for those too. And then I guess Tyler Technologies solved their issues, and we're confident with the amount of resources they can give us. So we're starting up with e-filing this month in District 5. So with that, we may have some more updates too, beginning on November 16th as they get ready to do the official launch, which is our next Bar Talk segment. We also have with us today John Kurt, who has been, I think, practicing in as an attorney in the real estate sector for over 20 years, I think. Right, John? No, you're on mute, just so you know, John.
Yeah, no, yeah, well, if you count my time in Vermont, I think this is year 26 or 27. Can't believe
There you
I'm that
go.
old.
Yes, and I've always relied on your advice too when we're doing some title work together, and I appreciate you joining us for Bar Talk today, and in particular, John, and correct me if I'm wrong, you've chaired this year our title standards subsection of our real estate section, and developed some new title standards that were adopted, I believe, at the beginning of this year. And I hope that when you share with us how the pandemic has affected real estate here in Maine and your business, that you can also tell us a little bit about the title standards. John, floor is yours.
All right, thanks, Thad. Welcome, everybody. So I'm I gotta get my view options here so I can see who's out there in the world. There we go. Okay. So in terms of the business side of things, what we're, anyone who's out there who's involved in real estate knows that the business has been absolutely crazy. We are seeing both purchases and refinances in terms of numbers of transactions just being absolutely off the charts. Lots of cash purchases from particularly out-of-state buyers particularly in Cumberland and York County. You're seeing a lot of big ticket out-of-state cash buyers. I think we're running right now about 60% purchases and about 40% refinances. That number has been pretty consistent since about July. I think we may see another dip in residential mortgage rates, so that may trigger another mini refi boom, or as my colleague here, Eric Schaefer, likes to call it, the sugar high. So I don't really anticipate, from what I'm hearing from everybody, that's going to slow down very much. We're very busy, and we're starting to see, at least from my perspective as a guy who lived the foreclosure bubble, real estate bubble, foreclosure boom, whatever you want to call it, on the ground in 2007, 2008. I see some of those underwriting practices / questionable practices starting to creep back in a little bit. Anyone who's refinanced in the last 6 months will know that they didn't have to pay for an appraisal for the most part, because now, particularly in southern Maine, the appraisals are being waived. Number one, because the value is there, and number two, obviously, because of COVID. They don't want people traipsing around other people's houses. In terms of the other COVID effect on our business, we were just starting to allow more people in the room, I guess is the best way to put it, until the new executive order came out last week. So I think we're going to have to go back to our old practices. Our office never closed. We've been masking and gloving until my hands couldn't take it anymore. Since, I guess, the 16th or 17th of March. It's actually worked pretty well. Where we've gotten the system down, the buyers understand, the sellers understand. Every once in a while, we will have someone complain that they want to have their realtor in the room with them. But for the most part, we're able to keep them available by phone. If we have an elderly buyer or seller, we usually let them have a support person in the room. We'll see what happens going forward. We have not, I believe we have done one closing using the remote notarization provisions that the governor put in place. It was not designed for real estate transactions. It was designed for estate planning purposes. It does not work well for real estate transactions. It's very cumbersome, requires a lot more technology proficiency than I have. That's why we let Eric do it. in terms of issues that I'm seeing more frequently now in the title world, maybe it's just me, but we're seeing a lot of subdivision issues and have been for the last few months, particularly where people are redividing lots on a previously approved plan. It's very important to remember that in most towns in Maine, if you redivide a previously approved lot, then chances are very good that it's going to require planning board approval to do so. And it is much better to get that approval up front than it is to have someone like me tell you afterwards that you need it. Another interesting thing that we've been coming across lately is towns that are now requiring town approval, particularly code officer approval, for single lot divisions of land. So even though it does not trigger subdivision approval, it still requires scrutiny by the code enforcement officer to make sure that the lot is a buildable lot. And I think in general, we are going to see code enforcement issues become more and more significant as title issues in Maine. I know people have been fighting against it for years, but it really, when you think about, oh, well, that's not a title issue, that's a use issue. Well, it's a title issue if someone sells you a piece of land for $200,000 that you're going to build your dream home on, and you can't build on it because the lot doesn't comply with the town zoning requirements. I think that is a very substantial issue that people need to look into. Is it a title issue? No. Is it the buyer side doing their due diligence? Yes. Is it the seller side really making representations about accurate representations about what they're selling? So in terms of next on title standards, we had a whole slew of title standards that we approved. Sorry about that. We had a whole slew of title standards that we had approved back in the spring.
John?
Yes.
John, this is Thaddeus. Hey, before you get into the title standards you've approved, can you just give us a 30-second thumbnail about, for those that might not be as familiar with what title standards are, about how important those are and how they generated and why you chair the committee?
So title standards, basically the title standards are, what would be the best way to describe them? The collective opinion / wisdom of a bunch of real estate practitioners in Maine. They have been in development, redrafting, modification, addition, editing, etc., since the early 1960s. And the title standards now are, while they do not constitute a legal opinion, they do, or something that a court can rely upon. Occasionally, Maine courts will cite the title standards in real estate cases. They are certainly standards of practice in a litigation setting where someone's going to argue that they didn't comply. For instance, someone doing a title search did not comply with the requirements of the title standards. And in general, I think, having practiced in 2 jurisdictions, Maine has very comprehensive title standards. It covers a lot of different areas. If I can find my book, it's buried under my desk here somewhere. But we cover all sorts of different areas in our title standards. There are plenty of statutory citations, plenty of case citations that can give you some guidance if you're looking. You can't have a case involving real estate. As far as access to the title standards, if you are a member of the Maine State Bar Association, You can access those standards on CaseMaker, and those are going to be updated going forward. You can also order paper copies from the Bar Association. I like paper copies because I write all these cryptic little notes all over the place. And I keep all of the minutes and working versions of all of the title standards that I've been involved with since I joined the section, I think, or since I started going to the meetings, I think in 2012. So it's now beginning to look like, you know, a DOS user's manual at this point, because it's about 10 inches thick. In terms, does anyone have any other questions about the title standards, first of all? Nope, hearing none. So in the last year, our biggest change in the title standards have involved what we call the 700 series, which those are all of the title standards that deal with probate issues. And that is because obviously there was a substantial overhaul of the probate code effective September 1 of 2019. So first of all, obviously we had to change all the statutory references in the title standards, but there were also some very substantive changes that took place in the probate code that required pretty substantial rewrites of the 700s. We had submitted, and everybody was really happy about it. In particular, Title Standard 706, which is one that I use quite frequently when dealing with estates that have either not been probated or have not had the assets or real estate distributed out of them. We had submitted that for approval when someone brought to our attention the somewhat cryptic language in 18C 3-108, which calls into question what we casually refer to as the 3-year rule. And it may be that the 3-year rule does not apply anymore. Another place where we see the title standards being employed quite frequently deals with tax titles. That title standard is going to need to be also revised slightly because section is at 946, I believe, the challenge period for tax acquired title has now been reduced from 15 years to 5 years. Title Standard 302, which deals with powers of attorney, has also been substantially revised. And it was actually revised prior to the adoption of the new probate code, and it actually needs to be revised again because there are some holes in the new power of attorney statute that the title standard doesn't really contemplate. The other title standards that we have seen very substantially revised are all of the standards regarding joint tenancy, and which will require a further revision now because again there are some changes in the probate code, and actually there probably are going to need to be some revisions in the new probate code regarding some conflict between Maine case law and the new probate code in determining what is or is not a joint tenancy. If you have a question about that, call Sam Kilborn because he knows. That's what I do when I have a question. Other issues that we're seeing fairly frequently these days, believe it or not, access is still an issue in Maine. I think that folks in Southern Maine tend to ignore or maybe not think that access is a problem. I have a subdivision in Gorham right now that has been approved. And so I think it's a 5 or 6 lot subdivision. They don't have any access. And the town approved it without the access, which I found somewhat odd. But it's very important to consider where your access is coming from and exactly what you can do with it. Obviously, people are still fighting over access to the waterfront, all up and down the coast and around several lakes. The Paper Street problem is still alive and kicking. I know of a couple that are still, folks are still arguing about it in Falmouth, and I believe also in Cumberland. Trying to think of other, I don't know if we call them issues, but maybe pet peeves for you folks out there who also do family law. We actually did have we had a webinar a couple years, I think it was about 3 years ago now, regarding the intersection of family law and real estate and the importance of getting an adequate legal description in your divorce abstract. An adequate legal description is generally not a tax map and lot number, nor is it the street address of the property. It either has to be a meets and bounds description, or it has to be a reference to an instrument recorded in the Registry of Deeds. Furthermore, this is the son of an English teacher saying, if you're going to set aside the property to one or the other ex-spouse in the abstract, say the property is set aside. Please don't say the property shall be set aside, because some of us believe that that calls for another act in the future in order to have the title be properly vested in the spouse that was awarded the property in the first place.
John, I have a question
Yes.
that came up. Are there any title issues that you see with the new conveyance on death deed referenced under 18C, and is Title 33 being revised for the new type of deed?
We haven't seen any issues with them yet, other than if someone, the only issue that we've seen here is someone has called us and asked us to do a deed and we say no. There are too many pitfalls involved with those transfer on death deeds. Hang on one sec, gotta close my door. There are too many pitfalls following the chain of title with those deeds, and we're not doing them, and I know a lot of other practitioners are not doing them as well. I do not think Title 33 will be revised to include that as a statutory form, because it doesn't, you can accomplish what you need in a transfer on death deed by putting the magic language in from the statute. And Short Form Deeds Act hasn't really been revised in a long time. I could look and see when the last revision date, but it's way back, other than the joint tenancy. We haven't seen one of those transfer on death deeds come up in a search yet, but I personally do not like them. I think it was a really bad idea, because it just, there are things that work great in Arizona that don't work in Maine. And I actually was on a phone call this morning with an attorney from Indiana whose client is purchasing a piece of property that my client sold in 2017, and they're claiming that their title insurance underwriter does not believe that the legal description of one of the parcels is accurate enough. And my response was, what do you mean? It says the fee under the 60-foot wide easement that's shown on the survey. What more do you need? It's right there in black and white, or if you have a color printer, color. But they actually want to meet some balanced description because that's what they're used to. So I think the same, it applies to the transfer on death deeds as well. I'm still seeing a lot of homemade, particularly homemade powers of attorney. LegalZoom has not caught up yet. And so we're getting people who are trying to use durable powers of attorney from LegalZoom in real estate transactions, and they don't work because the statutory references are incorrect. And under the terms of the statute, not only is it not a valid durable power of attorney, it's not a valid power of attorney at all. And so that's a do-over.
Yeah, and John,
Yeah.
was it about 5 years ago that we changed the statute on the power of attorney and
So it changed
Maine?
the first, well, since I've been here, it changed in 2004. The statutory notices changed in 2004. Then the statutory notices changed again in 2005. Then the statutory notices changed again in 2010. And the statutory notices have now changed again as of 2019. What is significant with the 2010 changes, and this was something that really only sort of came to light in the last couple of years, is there's a hidden provision in the 2010 statute that says all powers of attorney are presumed to be durable. But in order to be unless you say otherwise, so you have to say this is a non-durable power of attorney. And all powers of attorney that are governed by Maine law must have the appropriate statutory language from, it was originally from 5505, and then it was 5905, and now it's still 5905, I guess, but it's 18C. And if you didn't have the right statutory language, you didn't have a valid durable power of attorney. Because you didn't say it was non-durable, you don't have a valid power of attorney at all. This is a problem. There is a small curative provision in the new statute that basically says if a power of attorney has been of record for 2 years and the statutory references are incorrect, then any actions taken pursuant to that power of attorney are presumed to be valid. We haven't gotten an adequate answer from the probate and estate people whether or not they intended that savings provision to apply to all powers of attorney or just the powers of attorney from September 1, 2019 going forward. So that's another issue that comes up every once in a while.
John,
Yes.
I just want to say thank you for joining us today.
Okay.
I know there's so much to share with us, but
Yep. No, I wasn't sure how much time I had.
we're running out of it. I wanted to offer you any last thoughts before we finish up the rest of our agenda. And of course, you're welcome to complete the agenda with us, but and Angela might have other questions. I don't know.
Well, the thing I would say is search early and search often. So that's the do a good title search and read your title standards. Thank you all very much.
Thank you, John. I really appreciate you joining us today. And of course, you are welcome. Yes. Thank you.
Have a great day.
Thanks, John.
You are welcome.
I do want to make an announcement because I heard from VLP and they've seen a big uptick in real estate questions on free legal answers, and they have a serious need for attorneys with real estate experience. So most of the questions focus on the boundary title issues that seem to have arisen due to people spending lots of time at home and deciding to push boundaries literally, putting up fences and easements, right of ways, like John mentioned. And then there are a lot of questions having to do with unwanted guests and how to get them out of a private home. So if you have time to donate some of your time to the VLP and the Free Legal Answers Maine, VLP would greatly appreciate it. And then very quickly on the business side updates, we will be closed on Wednesday due to Veterans Day, and we want to thank all of our veterans for their service. You should have seen some emails requesting proposals for our annual bar conference or winter bar conference that's coming up in January. We really need some CLE proposals that will be held virtually in January. As I mentioned, those dates are right there. If you're in District 3, which is Cumberland County, there is an election going on for two of your 3 Board of Governors reps. Please get in and vote before the end of, that's this week, isn't it? No, next week, the end of next week. Legal Year in Review registration is open online. And next week we'll have Elizabeth Stout from VLP and possibly another guest. We're working on that. So stay tuned.
Thank you, Angela. And that other guest we're aiming at is related to risk of law practice. So we're hoping to get someone to speak with us about liability risk. And I meant to say, with the COVID-19 phased management plan, the big highlight from there is that we're going to civilian jury trials or civil jury trials sometime in 2021. So they're being pushed out further, as well as small claims hearings and some other special hearings. So that's going to be a rule of law issue for us if that keeps tracking out. And to piggyback on what Angela said, thank you to our veterans for swearing to uphold the ideals that this country holds. Thank you, everyone. We'll see you next week.
Thanks, Thad.